Good evening, and thank you for joining us. Now, among the other many things going on in our country, we do know that the government decided to release new rules for social media, digital media, and for streaming platforms. Now, on the technical note of how these rules will work, we put up a video yesterday in a discussion. There's a link on this video as well, so you can take a look at that. But on closer examination of these rules, it's obvious that this is a turning point in the history of the internet in our country, because as the rules stand right now, if they're implemented, it will change the way you communicate. They will change the way you consume content. They will change the way you are informed about what's going on in the country because of the way they're designed. So while we talked about the technicality of the rules yesterday, today we're going to talk about the legal aspect and how constitutional these rules are in the way they're designed. To help me answer these questions and help us understand this better, Dr. Menaka Guruswamy joins me right now. She's a senior advocate with the Supreme Court, and she's a leading constitutional and civil rights lawyer who has examined many things and argued many matters before the court to do with our constitution. Dr. Guruswamy, good evening, and thank you for making time for us to explain to our very young audience what these regulations will mean. I take it you've had some time to look through it over the last few hours. And there are several things, and I've broken this up to several problems that various people have identified. But my flat out first question to you is this. Are these rules constitutional? Because they seem to be stepping on the toes of privacy. They seem to be stepping on the toes of freedom of speech. They seem to be even perhaps extending the IT Act beyond what it should be.
Yeah. Well, good evening, and thank you, Ms. D'Souza, for having me on your show. As you know, I'm a great fan of your work. I'm really happy to be here. I think these are all very good and very important questions. I completely agree with you. This is a turning moment, not just in how the internet will be regulated in India. It's a turning moment in how artistic freedom will be regulated, in how the press will be regulated, in how our personal communication will be regulated, essentially how we will be regulated as Indians, right? So I think the rules that the ministries brought out, that the government brought out on the 25th of February, they were notified in the Gazette on the 25th of February, are extremely significant. As your viewers now know, it regulates significant social media intermediaries, digital media, and OTT platforms like Netflix and Amazon Prime. So these are three categories of services, shall we say, to start with, that are regulated. I want to specify these three categories of services because each has and plays a different function. So when we assess constitutionality, we also assess, well, what is the object of legislation or delegated legislation? We also assess, is it arbitrary? Is it proportionate? We also assess what is it in terms of consonance of constitution with constitutional values like privacy, dignity, equality, freedom of speech, expression, conscience. Does it chill speech? Does it chill expression? Or does it enable it? Now, first I want to start by saying, Faye, is that no one denies, right, that the internet, that social media platforms do need to be regulated. No one denies this, right? All over the world, this is a quest, right? In most constitutional democracies, the quest for regulation is a careful one where you balance competing interests. You balance the interests of speech and expression versus interests that we have as a society in protecting our children, in fact, in regulating hate speech, and in fact, in keeping our citizens safe, right? So there are interests that you balance, and including also the most important interest in keeping your country safe, right? So we're not at issue or odds here on the need to regulate. What we are at issue with is how you regulate, right? How do you come up with rules that will regulate our entire fabric of thought and expression, right? Have you consulted? Is it a multilateral conversation? And that's the first thing. What was that conversation? Who were the stakeholders? Did you draw in opinion both from experts, entities that that are going to be regulated, as well as citizens. In constitutional democracies, this is the expectation before you bring in a new legal paradigm, right? So that's the first thing. The second thing is that when you are trying to regulate multifarious entities like this, which each have different end products, the purpose of mediums, OTT platforms like Netflix or Amazon Prime is entertainment, artistic freedom, right? Storytelling with artistic freedom and entertainment in mind. The purpose of digital media, for example, Scroll, Quint, Wire, etc., is the press, is to hold governments to account, is to break stories of importance that citizens need to know, right? These are two different functions. I'm giving this illustration because the new rules seek to regulate two very, very different entities, the press, entertainment, with the same oversight mechanism, right? This is the issue here. When we assess constitutionality, sorry,
yes.
Go ahead.
Go ahead. Sorry, I beg your pardon. Finish.
When we assess constitutionality, it's not just about impugning motive. I'm not interested in which party, is passing laws or which party, is opposing it. That's not my interest here. I am interested in the legality, the illegality, the constitutionality, the unconstitutionality of such rules, of any law. That's what I'm interested in. I'm not here to, assuage interests or ascribe motives, right? So mine is an objective assessment.
So let's take it piece by piece, and I've tried to break it down because it's a 30-page document, but there are some things that jump out of the page. And explain this to us, as if you were talking to a 12-year-old. First of all, is the question of messaging. And while we can all, say, okay, social media and OTT streaming platforms, Netflix and this and that, these are all luxuries of young people. Right. Messaging and WhatsApp, and a lot of people who then migrated to Signal. Yeah. What this rule also says is that these platforms should be willing to share and disclose the origin point of a message, if asked for, so by a court or by any department of the government. Now, we understand that this breaks entirely the whole idea of end-to-end encryption. So the current infrastructure that these companies have will no longer be able to function under this rule. But more importantly, this will actually have to trace the person sending the message and read the content of the message. Does it violate our right to privacy given to us by the Supreme Court?
No, absolutely. I mean, this certainly seems to implicate rights to privacy, right? No one is denying, again, that you need certain mechanisms to address issues of child abuse, pornography, all of that. No one's denying that. And that is done all over the world. See, this is not just an experience for India, right? This is happening all over the world. But all over the world, these questions of encryption are treated very differently, right? And so why do I say this, right? So first thing to remember is that you cannot just assess the rules in isolation. The rules exist with two other features, that also impact them and impact us. One, there is no standalone data protection law in India, none, right? So that does not exist. There's a bill that's pending, but there is no standalone data protection law, firstly. Secondly, the 2009 variation of the IT Act actually provides for in certain cases, decryption to be provided for. So you already have that. Now in 2021, you've got a third thing, which says that the first originator's identity must be disclosed. So no data is protected. So if the government is now saying in 2021 that, no, we're not after the attachment, we're not after the message, only the messenger, but they already have access to the message. They don't need these rules to talk about the message. See, that's the important thing. How do you assess the need for legislation? How do you assess if legislation or rules are disproportionate to the interests that they seek to serve or are overbearing on our fundamental rights? You do so by seeing, one, what is already there, and two, what is being infringed on by what exists at present. And so you already have provision for decryption. You already have the lack of, a data protection law. Now you have this, where the identity of who sends out the message, the first originator, Rule 4.2, now intermediaries will have to disclose that identity. That really, to my mind, disproportionately burdens the rights to privacy, speech, expression, and conscience.
It also says mischievous messages, and a lot of this document is peppered with these vague words, right? Mysterious, dangerous, unlawful, which is not defined. And it's also vague as to who makes that decision, who decides what is mischievous or not. So, for example, let's assume I sent you a message that you thought was funny, and you sent it on to somebody else who thought it was offensive, but not in the context that I sent it to you. So who decides what mischief is, and under what law is mischief illegal in this country?
This is exactly right. So even though the social media intermediary is expected to set up a grievance officer, so on, and these are not bad things, right? It's a good thing to have a grievance officer. The issue really is that there are two fragments which are supposed to kind of adjudicate this, and these two fragments are entirely different. And I say fragments because they're not correlated to each other. One, you can have this identity being revealed by an order of a court, so this is rule 3D, a court of competent jurisdiction, or and this is very important, 3D also says or the appropriate government officer. So either a court or the government in place will decide whether something is mischievous, or will decide if something is defamatory, obscene, harmful to a child. No issue. I think it's fairly clear what would be harmful to a child, but also will decide if something violates public order. Also will decide if something is an incitement to an offense. Now, I understand a court of competent jurisdiction, and we can think about what is that court of competent jurisdiction. But an appropriate government officer is going to adjudicate these matters which really clearly need legal training and which clearly need an objective assessment. So the issue is not the substratum of redressal, right? The grievance redressal officer, that is a very good thing. You have to respond in a certain period of time. You have to give reasons if you take down something. Those are all good things. Those are very, very good things. But the issue really is who adjudicates. And only the judiciary should be allowed to adjudicate. And within that, look, in constitutional law, one of the most ambiguous, amorphous, vast area, which is so deeply contested, is something simple, like what is public order? Because it is so contingent on who is assessing.
Yeah.
Right? But, so the issue really is now if you have a government official assessing this, you can well imagine how broad anything could be offensive to public order.
There are also other, and the document uses a lot of the exceptions under our freedom of expression fundamental laws. So it says interests of sovereignty, integrity of India, security of state, friendly relations with foreign state, all of those things which are already in the Constitution, and we understand that. But words like insulting, libelous, inconsistent, those words are vague. And like you said, to have a government body or a government official make these decisions are one aim. But, the question that I have is this. Our government has displayed a tendency to confuse dissent for sedition recently, as was pointed out by a court in the Disha Ravi case.
Yeah.
Is all of this now fertile breeding ground for more such confusion?
I think the real issue is, you look at the political substrata, you look at the context in which these platforms, OTT platforms, social mediaries, and digital media operate today, right? And I want to give this because I think you're on to something, Faye, and I think it's important to address it. The context in which they operate is, in any case, if something offends you, you get to go to court, as OTT platforms have understood, right? So you already have existing mechanism in place, right? So it's not like, if you find something offensive, you have no remedy. So that's the first thing. Netflix, Amazon have learned that, in fact, the Indian Penal Code is extremely potent in slowing down their functioning, right? If citizens find something, which is going to offend them. So that mechanism already exists, right? Digital media has also learned that that mechanism already exists. It is not a situation in which there is no remedy at present. So exactly what is it that these rules are trying to do? Why is it that both OTT platforms and digital media now need to have a grievance officer, an independent body at level 2 constituted by their association, and then an oversight mechanism that is established by the ministry, which is an interdepartmental committee? Why do you need 2 and 3? A redressal officer, a grievance officer, no issue, because that's your point of contact, right? Why do you need 2 and 3 to regulate something, one platform or one nature of platform that is there for entertainment, and the other nature of platform, which is simply the press? Digital media is the press, right, on a different medium. So why can that press not simply be regulated by the mechanisms that exist at present? An association that would speak to the mechanisms that exist at present with a little tweaking. Why is it now that the press will be regulated by an oversight mechanism established by a governmental body, which is basically going to be an interdepartmental committee, presumably consisting of bureaucrats?
So just to explain to our audience this, as it stands right now for newspapers and for television, as far as journalism is concerned, there are self-regulatory bodies, which are bodies that are created by the industry themselves. These are journalists who come together, and they regulate themselves. And if you have a problem with content that is put out, or with something that's been authored or put out by any of the journalists, you can go to court. That's your second route. What these rules do for digital platforms is that you can self-regulate, but there is over and above that a committee of government bureaucrats, no representatives of industry, no retired judges, government bureaucrats who will then override any decision. So this is effectively like telling the children, you can decide what you want to have for dinner, but if I don't like it, I will change the menu. You will have to eat whatever I make for you. So that self-regulation is meaningless if it's going to be overridden by somebody else. So effectively, the argument that's been made that let's make a level playing field for these two is not true.
No, it's not just about level playing field. Level playing field means equal access to resources, right? But level playing field does not mean that you violate the separation of powers that the Constitution envisages, right? What are these separation of powers? The Constitution envisages that the judiciary will be distinct from the executive, will be distinct from the legislature, and there will be a free press that will hold all three to account. That is distinct from the other three. You are now collapsing the executive, bureaucracy, and the press, because for the first time, the executive, an intergovernmental committee, will be able to regulate what should really be the fourth pillar of a constitutional democracy, a free and independent press. So neither is the press going to be free nor independent.
I feel like there should be a moment of silence after what you just said. We have to also look at, the law under which these rules have been written, and the note on its very first sentence said that they're using the IT Act. The IT Act was never meant to regulate creators of content. It has been perhaps extended beyond its scope, and also done so without Parliament. There's no endorsement of Parliament in changing these rules or extending the scope of the IT Act. Is that illegal?
The thing is, clearly, I would hope that the legality of these rules will be tested, and will be tested seriously and tested in a court of law. That it's not just going to be, a conversation in op-eds and a conversation on digital media, but that in fact, you need rules like this tested in court, right? So I think its legality will be assessed by a court of law. But really, I completely agree with you. The IT Act was not meant to regulate such platforms. You needed to come up with legislation that was passed by Parliament, firstly, but bills that had been drafted after you went through a multilateral discussion process. Neither of those two phenomena have in fact occurred here, right? That's the first thing. The second thing I think is that something very distressing, which is that it is in line with the lack of parliamentary process, right, over the last couple of years in the way that rules, laws, ordinances, delegated legislation have been passed. You need parliament, and this is something larger, right? In the last year that was, and this is something that I find astonishing, in the last year that was, despite COVID, Indian parliament functioned very little as compared to, say, the United States, Brazil, parliaments in countries that were worse affected by COVID than arguably India has been, have functioned almost 3 times as much as Indian parliament. And that parliament was not convened over this year, was not convened either by digital means, which is how Brazilian parliament has been functioning, or physical means, which is how America's Congress and Senate have been functioning right through what has been a very badly hit country. Indian parliament, I think, functioned for 60 days or thereabouts in the whole year. So parliament has not functioned. You have not convened parliament. Parliament has to be convened by the government and the president. That has not happened. There is a mode of convening parliament which the constitution envisages, and you have not debated bills like this, rules like this, legislation like this that should have been debated, has not been debated, and has been passed as delegated legislation under IT Act rules. So there is something much larger here. There is something much larger, which is, how do we regulate today in India? How do we pass laws? Parliament is meant to debate law. After parliament debates, does a law get passed? If that preliminary process is not happening, then you have law being made by only the executive. That is not envisaged by the Constitution.
Dr. Guruswamy, the other problem was there were a large number of people from industry who came out and said, hey, you know what, we were not consulted. And this is to do with the streaming video OTT platforms who had formed an association and it volunteered self-regulation, they volunteered consultation, but they were not consulted. Also, digital news media, who have also formed associations, said we were not consulted either. Parliament didn't discuss these rules. So effectively, all of the things that you listed out at the beginning of this discussion on how a healthy democracy needs to function, which is to consult all of the stakeholders, maybe refer it to a committee of experts or a joint parliamentary committee, none of those things have happened. So, are we now running roughshod on all process?
What process? The lawmaking process is uniquely positioned in India today. What we know today of lawmaking is rules like this, right? There is great benefit to having a deliberative democracy. That's the point, right? When you don't convene parliament, you don't have a conversation on dramatic, legal paradigms like the one you've just introduced. You don't do that. You don't take people into confidence. Then the problem really is that you don't have the benefit of their wisdom and expertise either. You don't have the benefit of knowing what are people's needs. You don't have the benefit of the expertise of industry. No one is questioning the need to regulate. We are questioning today the form of regulation, who is being consulted in regulation, and how you are arriving at the text of those regulations. See, the difference between running, a unit, maybe even even corporations function under the Companies Act. You need deliberation, you need board of directors to meet. But the difference between a private proprietorship and a constitutional democracy is one requires deliberation and respect of process, and the other doesn't. I think that's really where we're at today.
And this is not the government, but there was the Allahabad High Court yesterday that rejected the anticipatory bail plea filed by Amazon Prime Video's India Originals head. Some of the observations made by that court were a little, we raised a few eyebrows. It said things like, and I quote, from an article in The Wire, it said, Western filmmakers have refrained from ridiculing Lord Jesus and the Prophet, but Hindi filmmakers have done so repeatedly and are still doing it they're unabashedly way with Hindu gods and goddesses. This tendency on the part of the Hindi film industry is growing, and if not curbed in time, it may have disastrous consequences for the Indian social, religious, and communal order. So what I'm worried about here, and it also, it mentioned Munawar Farooqui and making jokes that he didn't make, and the fact that it basically said that, these people are now making money of these ideas. This sort of gray area when it comes to artistic expression, freedom of speech, storytelling.
Yeah.
And because these rules that have been put out are not completely clear about what they're regulating, there's so much gray area and room here for hurt sentiment, for, this sort of interpretation.
Yeah.
Is that effectively going to lead to a crushing of artistic expression or self-censorship?
I think it's 2 or 3-fold, right? I mean, I would assume, Faye, that the industry that is going to be most affected by this would be interested in challenging it, right? I mean, this is really the heart of it, right? What we're talking about is one anticipatory bail application, right? And a profoundly, legitimate and just anticipatory bail application, right? And, in any society where bail is not taken seriously, well, jail becomes far too common. But leave that aside, right? Like, be that as it may. I think really the question is, what is the industry going to do in terms of testing regulations? What are social media platforms going to do in terms of, intermediaries? How will they test these rules? What is digital media going to do in terms of testing these rules? We do need the courts to weigh in. That's the real point here. We desperately need the courts to weigh in, because the courts eventually are the interpreters and the arbiters of the Constitution. We need that Constitution interpreter to weigh in on these rules. But the reality is that, the price of freedom is eternal vigilance.
Yes.
The price of freedom is eternal vigilance. And who has to now be eternally vigilant? Of course, citizens, but certainly industry. So we would hope, as a society that is deeply invested in thoughtful expression, and I'm not defending all expression. Some expression can be thoughtless, some can be hurtful, and some can be abusive. No question. But as a society that is invested in defending thoughtful expression, industry has to weigh in. The courts have to weigh in. You have to give courts the opportunity to adjudicate. And I think that's really what we would hope for.
Just arguing from the other side for a second here, it is true in the recent history of our country that we've had lynching that's taken place because of fake WhatsApp messages saying that these people are kidnappers. So if you see such a person, just beat them up. People have been beaten to death. We've had worries about fake news. We have, and this is a live example, during the Sushant Singh Rajput investigation, there were various channels that popped up on YouTube that were completely cooking up conspiracy theories, and they gained a lot of viewership. Viewership comes with a certain amount of payment from the platform. And so they popped up, they made the money, they left, but there was a fair amount of damage that was done in the process. So these are things that do need to be regulated. How should this have been done correctly?
Yeah. No, I think that, you're absolutely right, Faye. I mean, sort of the Sushant Singh Rajput case is just extraordinary, not just in terms of the actual case and the loss of, a gifted young actor, right? But in terms of how those who were thought to be relevant as part of that story were treated by the press. But the real issue is this, right? You need your associations to come together and to regulate better, right? Firstly, you need your associations to come together. You are a fragmented industry that is fragmented across the political partisan spectrum, not across the truth-telling spectrum. That's the problem, right? So your industry is fragmented in terms of it is taking sides which the Constitution doesn't expect. I mean, democracy is preserved not just by voting, it's preserved by the press, by an independent press. The press is not doing that, right? And there is a price to pay today, because even for channels that disagree or agree with certain political opinions, there is a price you pay when you lose your ability to express yourself. It's not just TRPs being the price you pay. There is a price you pay in terms of occupation. And the problem is it's a one-way street, right? So, I mean, even in terms of channels today that, that clearly, are sort of doing rather well in the times that we live in, there is a price you pay when your ability to tell stories is actually removed by legal process. Because governments change,
Yes.
Legal process stays. As we've learned from anti-terror laws, this is the point. As we've learned from anti-terror laws, that governments change, laws remain. So a law that suits you today because of a certain political persuasion could well be used against you tomorrow because of a different political persuasion.
Do you expect these regulations to wind up in court?
Well, I would hope so. I would hope so, because there is value in an objective, non-partisan, trained constitutional interpreter like the judiciary weighing in. There is deep value in that. I do think we need our top courts to weigh in on these rules. And I do hope that industry will take these rules to court.
All right. Dr. Guruswamy, many thanks for making time and answering our questions. It's always a pleasure to chat with you. Thank you.
Thank you so much, Faye.
For our viewers, remember our 9 o'clock news is up at 9 o'clock. 10 minutes of just the news of what happened today, old school style, no opinion, no debate, no shouting, no fuss. That's at 9 o'clock. Remember to tune in.